Next, we turn our attention to one of the most complex and sensitive areas that nursery owners face during safeguarding issues, and that's employment challenges. From managing staff under investigation to navigating suspension and potential claims, this is an area that demands care, consistency and legal clarity. To guide us through this, we're joined by Philip Richardson, Partner and Head of Employment at Stephensons Solicitors. Philip is highly experienced in helping organisations, particularly in the care and education sectors, handle employment matters with professionalism and compliance. Today he'll be sharing practical guidance on what to do, what not to do, and how to protect both you and your team, as well as your nursery in these difficult situations. Please welcome to the stage, Philip Richardson.
First of all, I've not got the excuse of this being an old photograph, unlike Chloe and Matthew. So, yeah, enough said about that picture, right, actually. Just to tell you what I'm going to be discussing in my slot, I'm going to be discussing the importance of investigations from a HR and employment law point of view, which is really what Matthew and Chloe have also touched on this morning. I'm going to be talking very briefly about the legal aspects, but I thought what was really important was to focus just more practically in terms of guiding you through an investigation and where I've seen failures, and hopefully that'll give you some good guidance and tips to move forward with. So first of all, just the legal aspects of things. Obviously, you'll all have contracts and policies and procedures in place. But the first thing just to ask is whether you know whether they're contractual or not. I don't know if any of you, everyone's looking at me puzzled, but actually your investigation and your disciplinary policies will probably state that they are non-contractual, which basically means they're there for guidance only, which gives you greater flexibility. It's worth you going back and having a look just to see whether your policies actually state that they're contractual. If they're contractual, if you don't follow those to the absolute letter, it does bring a risk of a breach of contract claim by an employee. So do check that, and hopefully the majority of your policies will be non-contractual, so they're there for guidance only. The next point is to ensure, obviously, your written policies are followed. And what I mean by that is I often see when I'm dealing with a claim, people steamroll ahead with the investigation. They're obviously quite concerned about the need to investigate it fully, but they actually forget to revert back to their own policies to ensure that they're being followed. And a judge will really scrutinise you at a later stage. If you're putting your policies and procedures in that tribunal bundle, you're going to come under scrutiny to ensure that they're followed. So do ensure that those written policies are followed. And then the legislation that's set down, what does that say about following a fair process and investigation? Well, the Employment Rights Act makes very clear that in a situation where an employee is dismissed and they bring a claim, it's fundamental that you do follow a fair process. You could have the best justification in the world for dismissing that member of staff. There could be an absolute clear safeguarding issue. But if you've not followed a process to sit behind that, then that will result in an unfair dismissal finding. So do obviously bear that in mind. And just a quick hands up around the room. Does anybody know what the ACAS Code of Practice is? Is anybody familiar with that at all? Hands, everyone? There's a few hands, but the majority of you are not familiar with that, and that's absolute key as far as a fair process, following a fair process. If that's what the tribunal look at, and that's what the judge will look at to see what type of process you've undertaken. And if you stick to that, then there's no risk of compensation being uplifted. But if an employee does bring a claim to an employment tribunal and is successful, and you haven't followed that guidance, the ACAS Code of Practice, the tribunal judge can uplift compensation by as much as 25%. So if you think like an average award being about £20,000, it's an extra £5,000 on top, so it is quite a significant uplift. So if there's one takeaway, you know, the majority aren't, you aren't aware of that, do go away and consider that guidance, because that's really fundamental to ensuring that a fair process is followed. And then just on the more practical side, I thought it'd be useful to put together a few slides and break down the key things to think about when you're investigating matters. And what we often find is that people sort of bulldoze into investigations. They sort of just get into it because they want to investigate it. But it is really key to do your planning and preparation first of all. You know, define the scope of your investigation. It might be very clear. There might just be one central allegation. But equally, there might be several incidents that have taken place, and you've got to investigate each one. Falling off the back of that are the trust and confidence issues. You know, has the employee misled you in some way? That could be a trust and confidence issue, and that would be scope for a misconduct investigation in itself. So for the investigating officer, it's really crucial to sit down and have a think about what they are going to be investigating. Obviously, you've got to consider the need to suspend as well. You know, subject to obviously your obligations to refer perhaps to LADO. What we often find is that people come through the advice line that we run for Dot to Dot and say, LADO haven't given me much guidance here, do I suspend or not? And I appreciate the difficulty, but obviously it's down on you as the nursery to decide whether to suspend. And the crucial thing there is considering the risk of harm. You know, is there a risk if that member of staff stays in the nursery setting? And if you're sort of weighing up whether to suspend or not and you're unsure, it's probably best to suspend. Is there a risk that that member of staff could prejudice the investigation by staying in the nursery working? Is there a risk that they could speak to other witnesses and other members of staff? Could they collude? Then that would obviously potentially prejudice the investigation. So obviously you've got that key consideration as to whether to suspend or not. Consider the welfare of all those involved as well. You know, you might have allegations that are completely unfounded against a member of staff. You're having to suspend them and they're sat at home, worried to death. You're getting on with the investigation, but there's no concern for their welfare. So do think back and make sure you're keeping in touch with those members of staff. Choose the right person to investigate the concerns. Just think that this is almost like a marathon, not a sprint. You know, an investigation might take place, but if that investigation warrants further action by way of disciplinary action, you've got to nominate senior staff who will be there to conduct a disciplinary and appeal. So actually, is the person you've nominated to undertake that investigation probably the appropriate person? So again, it's that forethought, thinking ahead, thinking who the right members of staff are. And also what we see, and certainly what I see as well when I'm sort of reading documents, it becomes clear when you're reading minutes of meetings where they've interviewed members of staff, where people have not been trained appropriately to do the investigation. So do ensure if you pick a manager or a deputy manager or whoever it is in your setting to do an investigation, that they're adequately trained. Because if you don't, it will come through, you know, at a later stage. It will show the degree of training that they've had to undertake that process. Developing a clear plan. That idea that you sort of have, you know, a lot of evidence to consider. You've got to speak to different members of staff. You're also very busy, you know, you've got a day job on top of all this. And the other members of staff might be out of the nursery, they might be on leave. So do consider the time frame and be realistic with that time frame. Give yourself enough opportunity to be able to undertake that full investigation. So then you've got a time frame by which you hope to have conducted that investigation. And then finally, prepare interview questions based on the evidence gathered. And again, this is something I see, probably Adam sees as well, when we're looking at notes of meetings and things like that. People asking closed questions, it just, you know, elicits a yes or no answer. You've got to think how you approach and ask open questions to be able to allow that person to fully respond. So that's really just the planning stage in terms of your investigations. And then you get round to conducting the interviews. What are the key things when you're conducting the interviews themselves? Well, first of all, consider privacy. You're in very busy settings. It's very loud. Some of the settings might only be small. You might have very limited room to undertake a proper investigation where you can concentrate fully. The member of staff, if they've been suspended, is it appropriate to ask them to come back into the setting? Is there a risk they might speak to other witnesses? Certainly we've had that before, and I've seen it in investigations. So do consider that idea of privacy and maintaining confidentiality. And if there's a risk, obviously you might need to choose a neutral venue. Sounds obvious, again, explaining the purpose of the meeting to that person. When you open that meeting, you want them to feel comfortable. You want them to be able to tell you things from their point of view. So it is important to reflect on what the allegations actually are and why they're here. It's also important to spell out your obligation as the investigating officer. You're not there to form a view on guilt. You're not there to form a view as to whether disciplinary action should be taken and at what level. You're there just to gather facts at this stage. So do remember, as the investigating officer, that that's your function. Listening actively and objectively, again, sort of an underrated skill is that, but again, it sort of comes across in meetings that we see, and when it's recorded down, you can see that people interrupt the witness. They ask them leading questions. They're asking them questions, you know, they're basically wanting to put words into the mouth. And, you know, if you read that, it becomes obvious that if that's read at a later stage by an employment tribunal judge, he'll question the, you know, just how objective that investigating officer's been. And you'll get more out of the witness that way. If you actually listen to them and let them speak, it'll make for a more fuller, objective investigation. As Matthew said earlier, document everything. That's really key. You're going into that meeting as the investigating officer to listen. Do take somebody in as a note taker. Take somebody in who you know can take a full note. Again, what we often see are notes of meetings which lack a lot of detail, so do consider that you make sure everything's documented. Some people ask us, can you record the meetings? Well, you can. You can record the meetings provided you've got the consent of the person who you're interviewing. If for any reason they're uncomfortable with recording the meeting, then obviously revert back to undertaking that detailed note of the meeting. Which brings me on to sort of the next point, and don't assume the person who you're interviewing isn't recording that meeting. The amount of times where we get to a tribunal, we go through the process of disclosure, and lo and behold, the person who's bringing the claim pulls out a recording of the meeting that you weren't aware of. Then there's arguments about whether it should be disclosed or not, but often, if there is a key point within that meeting, it will be disclosable. So, sounds awful to say, but start off on the premise that that interview could be recorded, that the employee could be recording that interview. And then finally, just provide an opportunity to respond right at the end of the interview with them. You've asked all your questions. The temptation could be, right, I'll just bring this to a close. Do give them the opportunity of saying, well, I've dealt with all my questions now. Have you got anything you want to add, you know, on top of what I've said? So you've dealt with your interviews. You've considered all the evidence. Presumably that's the end of it now. Do you need to consider anything further? Well, often, more often than not, you do. You know, you'll speak to somebody and they might refer to an email that they've got. They might say that such a body can vouch for what they've said. So there might be a need to go away and collect further documents and evidence, and that's what you should do as the investigating officer. Matthew's just spoken about preserving evidence, ensuring that, you know, emails are not deleted suddenly. We've had cases where CCTV coverage gets deleted. It just raises suspicion, doesn't it, at a later stage. So do ensure that you preserve all your evidence. And then finally, just to round it off, are there any further questions to the witnesses before you actually conclude the investigation? If you think you've missed any questions, it doesn't mean you don't have the chance to go back to those witnesses again and ask any final questions that you do have. And then bringing all this together, drawing conclusions and reporting. It's your obligation then as the investigating officer to report your findings. You'll have interviewed a lot of witnesses, potentially considered lots of evidence. You can't see the wood for the trees sometimes. You know, have a breather, go away from it, come back and reconsider and evaluate all that evidence. It's important all that's laid down and documented. And again, it's remembering your obligation as the investigating officer is not to form a view on a particular disciplinary sanction. You can make recommendations, so you can say as a result of that investigation that you don't think there's enough evidence to move forward with anything. You may make a recommendation that it should move forward to the disciplinary stage because there's sufficient evidence to show there's a case to answer. Or you can make a recommendation, for instance, that if there's a particular issue between members of staff, there might be a need for alternative resolution or something like that. So you can make recommendations. And obviously, as you go through this process, do ensure that confidentiality is maintained and all parties are kept updated. That idea about keeping all parties appraised is really important. You're sort of focused on the investigation, then there's somebody sat there at home suspended, worried to death about these things. Do ensure they're kept updated as to the progress of the investigation. So just bringing it all together, it's that idea of remembering to be impartial, ensure that you're following your own company policies, and as I said at the outset, really thinking about the ACAS code of practice, treating all parties with respect. You know, consciously or subconsciously, you may have formed a view on these things already. It's human nature, isn't it? But go into that process with an open mind, treat all parties with respect, and you're going to get it back. If somebody, you know, whoever you're interviewing gets a whiff of the fact that you formed a view on things, they're going to close down. So you've got to be as open as possible. And remember, as Matthew and Chloe have touched upon, to document everything as well. Do remember that your findings could be referred back to LADO. They might need some of the evidence. It could be referred back to Ofsted, even the police. But significantly, from our point of view anyway, it could be referred to at a later date at an employment tribunal. So do remember to ensure you do document everything. Use of CCTV, again, we've touched on this morning, but it can be used in investigations, but do consider as well how that cross-references to GDPR and consent. So do consider whether your policy is very clear that you make a member of staff aware that it can be used in investigations against them. It's not just enough just simply to say we're using it for safeguarding purposes. You need to let that member of staff know and ideally get informed consent from them. All that has to be put into a clear policy. As Matthew asked you all, the majority of you using CCTV, just ask yourselves what CCTV policy, if any, you've got in place. I use this, but in the last couple of weeks, I've looked at 2 handbooks and policies and procedures, and they're roughly about 4 or 5 lines, the CCTV policy. There's not a clear and detailed policy. So again, if there's a takeaway today, it might be worth you going having a look and reviewing your CCTV policy. Consider transparency and signage around the nursery. Ensure you're very clear that where you're using CCTV and that obviously it's only in open public spaces and not in highly sensitive areas. And continue to consult with staff and parents about it as well. Staff are obviously very, you know, they want to know why CCTV is being used, when it's going to be used, quite rightly so. So again, this isn't just about a policy which reflects, you know, what your members of staff should be considering, but also it should be reflected in terms of parental guidance as well. And another issue we've touched upon this morning is whistleblowing and safeguarding and the real importance of whistleblowing. Whilst I was doing this, there was this survey I came across which suggested that 52% of people surveyed didn't realise that they had protection in place if they whistleblew. And that was in a nursery context. So 52% of your staff, if that was taken, didn't know that protection was in place for them. So that's the key to being transparent and open with your members of staff about the importance of whistleblowing. They need to know they're going to be protected, not just by you guys, but also tell them openly and be transparent. The law makes it very clear that if you whistleblow, you will be protected. And it is very clear that they are. Under Section 47B of the Employment Rights Act, a worker has a right not to be subject to any detrimental treatment for making a protected disclosure. Protected disclosure is what we refer to as whistleblowing. And furthermore, if you do dismiss a member of staff because they have whistleblown, that will be automatically unfair. And the compensation in these types of claims, goes into the hundreds of thousands of pounds sometimes. Just is the significance of this type of issue. So yeah, whistleblowing very much protects employees and workers. So just very briefly, what is a protected disclosure? What is whistleblowing? Well, it's simply a disclosure of information that a member of staff gives you that tends to show one of the following things. That a criminal offence is being committed, that there's a failure to comply with a legal obligation, that there's a miscarriage of justice, that there's health and safety risk, or that there's environmental damage. Now, I had put safeguarding issues likely to come under the first two headings, but actually, I omitted to put health and safety risk, which is, a clear one, isn't it? But, those three headings, certainly in a nursery context, are, quite clear. And insofar as an investigation, it's all well and good to have policies and procedures, but it's important to make sure your staff are trained on them continually. We often get documentation to review, and you can see what some organisations do is give the employees at their induction almost like a checklist of policies that they should have read, and they just tick the boxes, don't they, and sign it. That's all well and good, but it doesn't show continual compliance. It doesn't show that they are trained on these things. And it goes back to this lack of awareness from staff. So just as much as it's great to have these policies and procedures in place, do make sure you keep a training record, to show that staff are continually trained on your policies and procedures. Because that is something that we see missed time and time again, and something that will probably be pulled up on by Ofsted and Lado. Nursery should have a clear policy dealing with whistleblowing, setting out the procedure if an employee wants to whistleblow and how that allegation is dealt with. And do remember, if you get an allegation, subject to your obligations to report, you've got to investigate that fully, and it's just in line with those steps that we've just taken. So considering access to support you have, really key that staff should feel like they can approach your members of staff, your key members of staff. You'll all have designated members of staff in place that deal with the safeguarding, deal with whistleblowing, but do you operate that culture? Do you operate a culture where people feel that they can comfortably and freely approach it if they've got any concerns? And that feeds into the case studies we'll be discussing this afternoon where, unfortunately, staff haven't felt that way. So that should be a key point. Depending on the size of your nursery, you may have somebody who is appointed to deal with your HR. In smaller settings, it might be somebody who wears a number of hats and is just taking that responsibility on. Do consider access to support you can give to that member of staff. They are doing the best, but they won't necessarily be HR trained. So is there somebody else you can refer them on to? And obviously, Dot to Dot, we run the advice line for them, and we get all manner of HR and employment issues that come through our door, and we're used to dealing with that type of those types of issues. So do consider where else you can reach out to. in terms of support. Consider your insurance policies. Obviously, Jackie touched on this morning, but at first sign of any problem, you should be notifying your insurer. Even if it doesn't escalate, at least then you've done your duty and your obligation and you have notified. And then it might, consider whether there's potential legal cover in place as well. But also, for instance, with Jackie and her team, if you reach out to them, they've got a number of professionals they can put you in contact with. We deal with Jackie all the time, and she'll be on the phone to me, and it's that type of openness and communication that you really benefit from by dealing with Dot to Dot. And then finally, just contact us at Stephensons. We're happy to help and have a chat so we can discuss different options with you. That's essentially me.